go over the time that was allotted for the hearing because it was really sort of the first round of hearings, big hearings in this case, and I wanted to give a full opportunity for the parties to set the background and provide the court context. But we did a lot of that yesterday, spent a lot of time on those issues. And so today, in the limited time that we have, really want to be focused on what I think is this issue of whether or not the order that was signed by Judge Plumlee on November 16th, or November 17th, excuse me, 2016, whether that order was signed in the absence of all jurisdiction. So let me go ahead and get Ms. Williams to initiate the live stream, and then I'll get us on the record and we'll go ahead and get started.
Your Honor, if I may, before we go on the record, this is a plea to the jurisdiction and not a 91A motion.
I'm sorry, counsel, correct. I was literally looking at my notes from the hearing for this afternoon, which of course is, but yes, the plea to the jurisdiction. Thank you.
No trouble.
All right, so I see that we've got the live stream initiated, and so let's go ahead and go on the record in cause number 2015614. This is the matter styled Bradley Miller versus Virginia Tally Dunn. And Mr. Miller, if you just state your name for the record.
Yes, Bradley Miller, plaintiff pro se.
Thank you. And appearing on behalf of the movement in the plea to the jurisdiction, Judge Andrea Plumlee, we have Mr. Graydon.
Yes, Your Honor.
Good morning. And on behalf of the Dallas County and Judge Diaz, who do we have appearing?
Earl Nesbitt, Your Honor.
Good morning.
Good morning.
Do we have anyone this morning on behalf of Defendant Patricia Rochelle? May be muted.
Ready? 214-697-6357.
So someone is not muted who probably should be. And so if you'll just make sure that when you're not speaking that your screen is muted.
Can the court hear me now?
I can hear you, yes.
Thank you, Your Honor. Yes, Michael Rochelle, appearing for Patricia Rochelle.
Thank you. And on behalf of the estate of Ms. Brousseau, who do we have appearing?
Yes, Your Honor, Elena Eric here representing the estate of Marian Michalopoulos, AKA Marian Brousseau.
Thank you. On behalf of the Hockaday School.
Jennifer Littman on behalf of the Hockaday School, Your Honor.
On behalf of John Shagru.
Dalton Harris and Laura Sherry, Your Honor.
Thank you. And do we have anyone on the line on behalf of the City of Dallas and Officer Starnell and Keller? No, we just had that hearing yesterday, and so I wasn't sure if anyone joined the line. All right, then the court is ready to proceed on the plea to the jurisdiction. Counsel.
Pardon me, Your Honor, I just wanted to announce my appearance for the record.
Go right ahead.
David Finley for defendants Tally Dunn and David Finley.
Thank you. Thank you. Did I miss anyone else? All right. Thank you very much. Okay, Mr. Graydon, as we discussed at the outset, the court has had the opportunity to read the plea, the response, the reply brief, and I also note that the court received your letter brief that provided the court with an excerpt that was inadvertently left out of the reply brief. And so I have reviewed all of those things. In the interest of time, I do have a hearing at 10:30. Yesterday, the court allowing you all to, or at least the lawyers in this proceeding and Mr. Miller in this proceeding to elaborate beyond the allotted time caused a lot of havoc on my docket. So I really have got to hold the line today because it just pretty much pushed the whole docket out and created an interesting scenario, to say the least. So we really got to get this in today within the time that has been allotted. Having said that, as I told you, I've read the briefs, and one of the central issues almost a threshold issue, Mr. Brayton, that perhaps you would argue cuts across much of the arguments, is this issue of whether or not the subject order, making reference now to the November 17th, 2016 order signed by Judge Plumlee, whether that order was signed by her in the absence of all jurisdiction. And so I'll let you elaborate on that and any other point that you feel like you just want to highlight with the court, and then I'll need to turn it over to Mr. Miller so I can wrap us within the 20 minutes we have remaining. You may proceed.
Your Honor, if I may, I understand that is what you see as the threshold issue. I see something else as a threshold issue here.
Go ahead.
I'd like to start with that before rolling into the other issue.
Sure.
The first is that in order for this court to find liability on behalf of Judge Plumlee, it is unquestionable that you will have to review the orders or the judicial actions of Judge Plumlee taken in the 330th District Court, all of which were under a cause number that is a family court divorce and subsequent custody proceeding. And the family code, section 155.002, says that the 330th District Court has continuing exclusive jurisdiction over these matters. So to the extent that Mr. Miller was able to present a viable claim, and I don't believe that he is, but even if he were able to, this court would not have jurisdiction to enter those orders because it would require you to pass judgment and alter or vacate orders from a court that has continuing and exclusive jurisdiction. The only court that could do that is an appellate court. And Mr. Miller tried that, and the appellate court, the Fifth Court of Appeals, as we show in Exhibit A to the plea to the jurisdiction, Exhibit, I believe it's B to the plea to the jurisdiction, says that they would not take up that matter because it was a final judgment and it was not timely appealed. The Fifth Circuit did not disturb the order or any of the orders that were entered in the 330th. And so I would submit to the court that this court cannot overrule the Court of Appeals and also the court that has continuing exclusive jurisdiction. And it would be required to do that in order to find any liability against Judge Plumlee. Having said that, I will now move on to the court's initial question about the November 17th, 2016 order. As we've briefed, the complete absence of all jurisdiction is a term that is differently defined in a context of judicial immunity. It requires the judge to take a private and non-judicial action rather than a judicial action. It is not a matter of
Go ahead, counsel.
whether or not that the court might have. In this case, the court did not exceed its
I'm sorry, Mr. Brayton.
jurisdiction.
Can you say your last statement? Your feed cut out.
Okay. I'm not sure exactly what I said, so I'll back up a moment. The context of judicial immunity requires a plaintiff to show that a judge took a private and non-judicial act in order to be in the absence of all jurisdiction. In this case, the argument is that the court lost jurisdiction between November 17th and November 18th. Before that date and after that date, the court had jurisdiction, and that is unquestioned. So the question is, was it in the complete absence of all jurisdiction? The courts are instructed by case law to liberally apply the definition of jurisdiction in favor of finding judicial immunity. That's the Brott case that we've briefed. Moreover, the court, when deciding whether or not it was in action in complete absence of all jurisdiction, looks not to the specific act in question, but to whether or not the court had jurisdiction to do that kind of thing. In this case, it is undisputed that this was a modification of a custody case. Mr. Miller has said that it remained in the 330th the entire time. Mr. Miller argues, or in his pleading, discusses how Judge Plumlee entered orders in that proceeding, signed a divorce decree, held hearings, quashed subpoenas, and yes, signed an order on November the 17th of 2016. It was an order that commemorated the decision that she had said verbally on the record at the end of trial in October of 2016. Did she have the authority to sign an entry of judgment commemorating the decision that she had made a month earlier? She did. The contested part is whether or not removal removes jurisdiction. And from an initial standpoint, no, it did not, because again, it's not the specific action, but it is whether or not the court had the ability to take that kind of action in a modification proceeding, and it did. But even so, as we demonstrated to the court, in the event that a removal is done more than 30 days after the defendant has notice, the removal is invalid, and the court order that is signed, if the state court signs an order during pendency of a removal that is then immediately vacated because it is untimely, the state court order is not void. It is a valid order. That is consistent with the Fifth Court of Appeals, who said you had 30 days to appeal the November 17th, 2016 order, and you did not do so. So it is not before the court, and it is jurisdictionally barred from being reviewed by the Fifth Court of Appeals. The case that stands for this is Parrish v. State, 285 Southwest 3rd, 86 at 89 and 90. And that case allowed an order to stand that was issued by a state court after removal, but before remand, because the remand was fatally defective for failing to comply with the procedure for removal at the federal court. Further, the Windsor v. Round case, 590 Southwest 3rd, 654 at 671, stands for the proposition that a defective removal does not void an order that was entered between filing of a notice of removal and remand. In this case, it is unquestioned that the federal court, although Mr. Miller filed a motion or a notice of removal, did not have the subject matter jurisdiction over the case in question. That's demonstrated by the fact that it remanded it the following day. That is also supported by the Fifth Circuit's opinion affirming that remand, which is Exhibit A to the plea to the jurisdiction. So this was not done in the absence of all jurisdiction. It was the kind of action that Judge Plumlee was authorized by law to do in a modification proceeding before her in the 330th court, which is a family court but has general jurisdiction. And the case law shows that orders that are signed in this circumstance are not void. So this is not in the complete absence of all jurisdiction. There is judicial immunity. Further, with respect to sovereign immunity, Mr. Miller suggests that the Heinrich case stands for the proposition that he can get prospective injunctive relief. And while that is generally accurate with respect to judges who are being sued for constitutional violations under 28 U.S. or under 1983. As we showed in the briefing, equitable relief is not available as a remedy against judges under 1983. So that is the nutshell version of our argument. I want to give you as much time as necessary for you to do that. If you have any questions, I'll be happy to answer them.
I don't have questions. The briefing was very thorough. Thank you. Mr. Miller, you have the remaining. Let's do try to do 7 minutes, Mr. Miller, so that we would have at least a moment for some rebuttal for the movement.
Yes, Your Honor. Initially, a procedural issue. I moved to strike the reply brief and letter brief that was filed on behalf of Judge Plumlee on May 12th and May 13th. Local Rule 2.09 requires that briefs be filed no later than 3 working days before the scheduled hearing. Neither one was. That's not that big of an issue, but I just wanted to put that forth.
Did you file a motion to strike pleading related to that?
I did not. I didn't have time to do it.
Okay.
I'm sorry. I had to prepare.
The only reason that I was asking is because I wanted to know if I missed that. I mean, generally my standard is if someone has filed something, even though they filed it outside the time that the local rules requires, if I have read it by the time we get to the hearing, then obviously it's a part of the information that's in my head that I know about the case. And so I just want to make that clear. That's the reason the court's considering it, because I wasn't aware of any desire to strike it. And so I read it, and obviously based on my comments here today, it's a part of the information that the court has in its head. So go ahead, Mr. Miller.
I'll move on. I have to commend Mr. Graydon for his creativity, but I don't think his legal argument holds water. This hearing and this issue hinges on what it means for a judge to have, quote, jurisdiction, or as occurred in this case, to act without jurisdiction. And I will show that the law is very clear on this point. Of course, we all know about the hearing that was scheduled for November 17th, 2016. There's a docket in my exhibits that I submitted, which we may or may not have time to get to, but I removed the case under 28 USC 1443. My removal did follow procedure. It was not defective under procedure. In fact, it was remanded, which shows that it did follow procedure. I filed a notice of case removal prior to that hearing. And then I personally served Ms. Rochelle, Defendant Rochelle, with the removal documents, informed her that the case had been removed. And she said, well, we'll see if Judge Plumlee thinks she removed the case. Apparently went in and had Judge Plumlee sign the order without jurisdiction. Jurisdiction, of course, is removed under section 1443 upon filing of the removal petition in federal court and the removal petition, a notice of removal, in state court, both of which I accomplished prior to that hearing at 9 a.m. on the November 17th, 2016.
Mr. Miller, what is your understanding of why the courts determined that the federal court did not have jurisdiction over your removal and that the removal was defective?
Yes, well, there's governing case law, which I have cited in my briefing. Well, first there's federal law, 28 U.S. Code 1446D, which says that, quote, promptly after the filing of such notice of removal of civil action, the defendant or defendants shall give written notice thereof to all adverse parties, which I did, and shall file a copy of the notice with the clerk of such state court, which I did, and which shall affect the removal, and state court shall proceed no further unless until the cases are remanded. And I'll go through the case law now supporting that. One of the earliest cases was National Steamship Co.
Excuse me, Mr. Miller, pardon me for interrupting,
Yes.
but what I'm asking you is,
Yes.
what did the federal court say was the reason it was remanding, and what did the Fifth Circuit say was the reason that remand was?
I see.
And
Yes,
what is your understanding of that?
Yes, upon review of my removal, they determined that they did not have subject matter jurisdiction under section 1443 because of a trio of U.S. Supreme Court cases, the first one being Georgia v. Rachel in 1969, which basically gutted the true meaning of the section 1443 language. But it doesn't matter. None of that matters. As long as you follow the procedure, the removal is still considered valid. And anything that happens in state court between removal and remand, even if the removal is found to be ineffective, is absolutely void, period. It doesn't matter if the court, federal district court decides later that your removal is ineffective because they didn't have jurisdiction. None of that matters. The only thing that matters is, when did you remove the case? Did anything happen beyond that point and prior to remand? In this case, that's exactly what happened. The date stamps on these documents clearly show that the case was removed to federal court. Judge Plumlee acted without jurisdiction, and then the case was remanded the next day on November 18th, 2016.
So I was asking because
Yes.
you know that part of the argument raised by the defendant Plumlee is that an untimely removal does not deprive the state court of jurisdiction. And as I understand it, the argument further goes, in his family law case, not only did plaintiff not remove his case within 30 days of service of summons, but by his own admission, a trial was held on October 18, 2016. So the attempted removal was 30 days after trial and therefore untimely. And so the argument continues that removal did not deprive the 3/30th of jurisdiction.
Well, I will address that as well. I think there's two flaws to that argument. The first is that the section 1443 stipulates that you remove your case within 30 days of first learning of your cause for removal. And I certainly did that. I didn't even know about removals until less than 30 days before I removed it. The reason I removed the case was that I suspected that Judge Plumlee was going to sign a proposed order that violated my constitutional rights. And that's exactly what she wound up doing. The other issue is that even if, and I'm going to say just point blank that the removal was not untimely under 1443, the removal was timely, which I stated in my removal petition, which is in the exhibits. It's in the text of Exhibit B, which is my federal removal notice of petition. But even so, the federal district court did not rule that the removal was untimely. That's never been an issue legally. But as I said, I learned of removal less than 30 days. The ability to remove and my cause of my grounds for removal less than 30 days before I filed. So that complies with the federal law under section 1443.
All right, thank you for that response. I do want to give you an opportunity to deal with some of the arguments that are raised around the Brandt versus West case, and in particular, this issue that even if your removal was proper, the standard that the court should be considering is whether or not defendant Plumlee had the jurisdiction necessary to sign an order of the kind that she signed in November of 2016 on November 17th. And that really is the focal point for the court in terms of analyzing whether or not her signing that order was clearly outside of the scope of jurisdiction. The Brandt case, as you likely know, because
Yes.
knowing you as I think I do right now, you probably have already read it. So you know that case has a lengthy discussion about this particular issue. And so I do want to give you the final minutes to respond in terms of your position on that proposition of law.
Absolutely. Two issues with the Brandt case. First of all, it's Texas Supreme Court precedent, and it's to any extent, or insofar as it contravenes the U.S. Supreme Court precedent that I have cited in my briefing, and that I will cite if I have time here, it wouldn't be valid because of the supremacy clause of the U.S. Constitution. The other issue is that Brandt is a case involving a motion to recuse. It is not a case involving a federal removal under federal statute. I think it's a different standard. It's a totally different circumstance. And the federal law and the U.S. Supreme Court precedent shows quite clearly that an action, even if it appears to be semi-judicial, if it's taken in absence of all jurisdiction, in the words of Bradley v. Fisher, in the words of Stump v. Sparkman and Morales v. Waco, it is non-judicial and it is deprived of immunity. That's the core of the issue here. That's exactly what Judge Plumlee did. Federal law dictates that when she performed that act, she was deprived of immunity, deprived of jurisdiction, and for that reason, she was deprived of immunity.
Finally, Mr. Miller, council has, Mr. Graydon has pointed out the language in section 1983 that basically carves out an exception as it relates to judges. And so to the extent that you try to carve the exception to sovereign immunity, that you have right to file suit for prospective injunctive relief, council argues that that sort of equitable relief is expressly not allowed as it relates to a judge and judicial actions.
Yes, as you mentioned, injunctive relief and actually attorney's fees would both be allowable under section 1983 in such a case. I would argue that section 1985 applies because Judge Plumlee was not acting in her judicial capacity. She was acting in a conspiracy as an individual, as a private individual. So for that reason, I think that overcomes the barrier to damages.
Mr. Graydon, I have about 30 seconds before I do need to get on the telephonic bridge for my next hearing, and I will leave it with you.
Yes, sir, Your Honor. The definition of judicial immunity is different, or excuse me, the definition of absence of jurisdiction is different in a judicial immunity context. At most, Mr. Miller is arguing that Judge Plumlee signed an order in error or incorrectly. And the Twilliger case out of Houston, citing Stump v. Sparkman that we've presented to the court, the Hensel v. Gerstein case, all of these say that errors, mistakes, even things done in the excess of a judge's authority are still included in judicial immunity, so long as they are the type of thing that a court can do. And again, the Brott case talks about how the court is to use an expansive view of whether or not something falls within judicial immunity. And I'll leave it to the court.
All right. Thank you all. We will have to wrap there. Of course, I'll see everybody back this afternoon on the 91A motion to dismiss. Thank you all. You're excused.
Excuse me, Your Honor, is that hearing not at 11 o'clock?
It is at 11 o'clock. My
Okay.
use of the term afternoon, I guess I'm used. When you've been up since 4:30 reading and getting prepared for the docket, it feels like it's going to be the afternoon for me. I've been going for a minute. So yes, it is at 11 o'clock. So I'll see you all this afternoon at 11 o'clock or later this morning.
Thank you.
Thank you.